Hello, dear students. I'm here again with this third lecture of mine on legislative drafting. I am Dr. Vibha Sharma, Associate Professor, Government Law College, Ajmer. In this video, I would be discussing with you the principles of legislative drafting. Believe you me, this is actually not an easy task to draft a legislation. But then, if the draftsman follows these principles, then definitely it would help him in the long way. So let's start with the principles of legislative drafting. Yes, legislative drafting is an art, but of course a difficult art. Good legislative drafting is an art rather than a science. We already know it. But we should know also that the legislative drafting is a skill acquired by the drafter through years of experience obtained through painstaking labor and work. This skill consists in using a proper language which establish an instant rapport with the people or citizen who are the subject matter of the legislation. And therefore, it is the paramount duty of the drafter to see that the legislative intent and policy, which is actually primarily others' ideas, is easily understood by the citizen and common man. And you know very well as to how very much difficult it is to give expression to the ideas of others, and that too in a concise and clear language. Because we know that the drafter is an important link between the executive government and the legislature or parliament of the country. And we also know that the legislation is that document which signifies the policies of the government in power, and once assented to by the head of the state becomes the law of the land till it is modified, changed, or repealed. And therefore, the drafter's job is to transmit the legislative policies of the executive into the draft legislation, which will then be introduced in Parliament for discussion and debate, and thereafter passed as an act, that we already have seen in the previous video. So we come to the essential requirements of a good draft. Now, the first and foremost would definitely be the basic legal knowledge. Now, knowledge of law is very much necessary because the familiarity with the law in general would actually take the drafter towards the goals which he tries to, or which he is trying to put in words. Now, one cannot draft satisfactorily unless one knows the law in general. And what is law? Okay. What one is going to produce is actually that part of the law which is not a block of apartments where each tenant lives separately from each other. Rather, the law is like a continuous stream. Really speaking, if you touch the stream at one point, it is bound to affect many other points in the stream, as it is a running stream. Likewise, the moment you touch any part of the law, some other part of the law is also going to be directly or indirectly affected, although one may not always be able to visualize that. And thus, the familiarity with the law in general is a very important part of the draftsperson's equipment. Then, of course, the mastery over language is necessary. Now, it is not enough for the draftsperson just to know the language like any other intellectual. Knowing the correct rules of grammar, of course, is very much required. But then we also know that the draftsman is using the language as a sole medium of his work, because his words which he or she uses will make the law. It covers not merely language as such, but also the structure of the sentences, the arrangement of and juxtaposition of words, the choice of diction, and above all, a certain amount of strength as well as an elegance. Here again, we have to also note that the draftsman should have the ability and competence combined with imagination and plenty of practice in doing his job, his or her job, right? Now, I would like to share an example with you so that you know as to how typical and actually how difficult is the art of legislative drafting. Suppose there is a provision where the duty is being imposed on a citizen or a person or an officer to carry out, that is, to do something as early as possible. So now, for example, the words available to him are as soon as possible, this should be done, or he or she should do it as quickly as possible, or he or she should do it without delay, right? And then there is the well-known phrase, which is well known to all of us, and that is within reasonable time, right? So the words used here actually convey the exact meaning and intention, which has got the strength as well as the elegance, right? When we say he or she should discharge the duty within reasonable time, then we actually are giving consideration to the person out of whom the duty is expected to be discharged, and also an indication to the person that it is to be done within a reasonable time, that is without much delay. Correct? Okay. Now we come to the last point, and that is after the draft is ready, the draftsman should refer this draft to several others, because, and moreover, the draftsmen generally sleep over their drafts for a day or two. And when they again sit to write it, then they themselves come up with so many improvisations. And when it is given to others, then the errors can be known more accurately and can be corrected. Yeah. So now moving on to the next aspect of this legislative drafting and understanding that it is an art. Okay, before starting with this summary of Montesquieu Rules, which was done by Dr. C.K. Ellen, it is worthwhile for us to know that on the principles of drafting itself, Bentham's work may be said to be the starting point from which the modern theory of drafting is derived. Now, without going into those many details, let's see these 7 rules which were laid down by Montesquieu in his Spirit of Laws, which was published in 1748. So as summarized by C.K. Allen, the first one is the style should be both concise and simple. Grandiose or rhetorical phrases are merely distracting surplusage, and hence it was said that the style should be concise and simple. It should be accurate and with precision. Then the second one is that the terms chosen should, as far as possible, be absolute and not relative, so as to leave the minimum of opportunity for individual differences of opinion. Then the third one was that the laws should confine themselves to the real and actual matters, avoiding the hypothetical or metaphorical situations. Otherwise, it would create a lot of confusions. Then, they should not confuse the main issue by putting a number of exceptions, limitations, modifications, etc., etc., unless they are absolutely necessary. And this particular rule is very clearly stating that there should be no confusion created in the main issues which are being dealt with. And again, it is very clearly pointed out that the provisions should not be argumentative, right? Because definitely it is dangerous to give detailed reasons for laws, for this merely opens the door to controversy, and therefore they should be as concise and accurate with precision. And the last one, that draftsmen should make all the efforts to reduce doubts, ambiguities, and mistakes to a minimum. It is said that they should maturely consider and also look into the aspect of their practical utility. Okay? Yes, of course. These are in addition to the rules that we already have seen in the previous slide. Okay? Only the important ones I have brought here on the slides. There are many more, of course, but as we go through them one by one, we will know their importance. So first of all, the object of the proposed legislation has to be very clear for the draftsman, because he or she is the one who would be writing something which actually would become the law of the land, unless modified, repealed, and so on. Then, the draftsman is also to consider whether the proposed legislation will be in conflict with the provisions of the Constitution. Because if that be the case, then all of the efforts will be wasted. And the draftsman will also will have to have in mind as to what all is already provided in the existing law on the subject. And it would further enlighten him into the aspect as to how the existing law might be affected by the proposed legislation. Because if this proposed legislation will affect the existing law in any way, then he has to have a provision to that effect in this proposed legislation. Correct? Then it is said that sentences must be simple to understand. Now, we all know that when in the beginning we read law, a provision in the act, we find it strange. We feel that it is not simple. But once we start reading it, then we realize that probably there is no other better way to put across something so simply, so clearly, which actually conveys the meaning, right? Then another one is that the sentence should be positive. Positive sentence is the rule, negative sentence an exception. Okay? And of course, generally, active voice should be used while writing a provision, especially when a power is conferred or duty is imposed. Now let's see the rest of them. Yes, some more principles on legislative drafting. Now these also are very simple to understand. We all know that generally the acts are in the present tense. Future tense and the past tense are used only to express the temporal relationship between two events. Then we already have read the interpretation of statutes and the rules contained therein, and therefore we very well know that different words must not be used to express the same idea. Otherwise, it would create a lot of confusion, correct? Likewise, the same word must not be used to express different ideas. Of course, monotony is a positive quality as far as the drafting of an act is concerned, and plain language should be adopted. We already are aware that the plain meaning rule actually rules the area of interpretation of statutes, correct? And of course, each clause is to contain only one idea. Suppose an idea is complicated and it is contained in the same clause, then it would give rise to more complications and confusions. And therefore, where an idea is complicated, subclauses should be used. And of course, avoid any designation of gender. I hope you already are aware of the General Clauses Act, which is in existence since 1897, and it also says that wherever he is used, then she is also included in it, unless otherwise is expressly provided. Okay, now moving on to the rules relating to the Indian draftsman. Now, here are the additional requirements for an Indian draftsman. Now, because of the peculiar aspects of India, and therefore it has been said that these are the additional requirements for an Indian draftsman. This is the last part of this video. And the first one is an intimate and full knowledge of the Indian statute book. We all know how many laws are already in existence. So the intimate and full knowledge is very much expected out of the draftsman. Then the familiarity with the legal principles expounded by the courts over a period of time. That is also necessary for the individual to keep in mind. Then full and intimate knowledge of the Constitution of India. We already know that ours is the lengthiest written constitution, and so the full and intimate knowledge would actually help the Indian draftsman a lot, especially the fundamental rights and the distribution of legislative powers. And familiarity with the General Clauses Act of 1897. Just now I've said about it, something about it, and I really hope that all of you already know as to what all is contained in this particular act. If not, then please go and take a look. Then, knowledge of procedure in parliament or legislative assemblies, the administration, the courts at work, societal living conditions, all these things should be in the mind of the draftsman while drafting a legislation. And then, of course, rules of interpretation adopted by the courts and the precedents. So this would definitely help the Indian draftsman in writing the law, which will actually become the law of the land. So I really hope that this video on principles of legislative drafting is helpful to you, and you will actually understand these fundamental aspects of legislative drafting, which is very much required. Okay, so all the very best in all you do. Please take very good care of yourselves, and good day. All the best. Bye.